in the room yet, but do we have any more participants? All we have are Kate and Fitz and they goober between the flags. Just members. Two, three, four, five, six.
We are live on YouTube now that we've started. So.
All right, but we don't have a quorum yet, do we?
Not.
I think I only get six.
I think you have
2,
seven.
3, 4, 5, 6, 7. Believe you're right.
2 online.
Yeah, 7. We do just have a quorum. All right, we're gonna wait just a minute because I'm still missing a couple of members. We do have a quorum, so we can start, but I'm gonna give it another couple of minutes here. So everybody that's watching on YouTube or elsewhere, just hang tight. Thank you. I was gonna, while we're waiting, I asked Roberta to hang around, and I should have introduced her just then, but I got distracted here. Everyone, this is Roberta Kaiser sitting here to my left. You may want to scoot over or talk and see if the camera picks you up.
That's okay. I don't really need to be seen. I'm here.
There's her
Whatever.
arm,
I'm
people
here. Yeah.
watching on the.
Here.
There she is. All right. So Roberta Kaiser is our new Katie. Our new Judiciary CSA came from state and local government, I believe. Glad to have Roberta here on the team, joining the rest of our fine folks at the committee that is superior to the Transportation Committee. And we're glad to have, again, I hope John's watching. Glad to have Roberta here. We'll get started in just a minute, everybody. Thank you. we're going to go ahead and get started. If members show up, they show up. If not, then they miss it. But we're 10 minutes in. We only had the room for an hour, and now we've lost 10 minutes, and I don't want to lose any more time. So with that, I call to order the first meeting on the Senate Standing Committee on Judiciary. Mr. Secretary, please call the roll.
Senator Berg,
Present in district.
Senator Carroll,
Here in the room.
Senator Kerr, Senator Neal,
Present from the 33rd District.
Senator Schickel, Senator Schroeder, President Stivers, Senator Turner, Senator West, Senator Wheeler, Chairman Westerfield.
Here. Seeing that we have a quorum and we're authorized to do business, we're going to jump right in. I'm going to go in order where I was, but I don't see Representative Fisher, so I don't know if he's here to testify yet. So we will go to House Bill 3 first, an act relating to civil actions and declaring an emergency, sponsored by Chairman Ed Massey. Chairman, come on up. Welcome for your first time, Chairman, to the upper chambers, finer, more polished Judiciary Committee. We're glad to have you.
Thank you. It's a pleasure to be here, members, and I really am honored to be in this role, and I appreciate the work that I've done with many of you, and certainly Chair Westerfield. This passed our body, of course, yesterday. This is House Bill 3, and let me start the exact way I presented it yesterday for those of you that may not be in the legal system. Currently, when an action is filed that involves typically a constitutional issue, administrative regulations, or many of our administrative agencies, it begins or is filed in the Franklin Circuit Court, where it's assigned to one of two trial judges, and that is where the case is disposed of or heard. Of course, the procedure after that is it goes to the appellate court and then subsequently to the Supreme Court. In essence, two judges in our entire Commonwealth are given the responsibility of handling all of those cases. And one of the concerns that many of my colleagues, and certainly in the House, have had is that their communities, their voters, are unrepresented in that respect because they don't know the judges in Franklin County, and additionally, people have to travel or commute to Franklin County in order to have these matters heard. This bill would change that process. What would happen with this bill is that three areas defined by population and geography would be established so that there would be a fair differential between these three areas. When a case would be filed in the county of the plaintiff's residence, then the Supreme Court Chief Justice would receive certification and then would randomly select three judges, one from each of the three areas, in order to be impaneled and to hear the case. So instead of one judge, we would have a three-judge panel. We would make an ability to make this publicly accessible. In fact, there's language that says that nothing would be sealed unless it's under federal or state mandate or law, so that attorneys, in essence, couldn't get together and keep the public from having information related to the particular case involving what we believe are very critical issues in our Commonwealth. This would allow many of our circuit judges to be able to sit on these very important matters. It wouldn't allow all of that to be thrust on to two judges, and certainly I'm not challenging, nor have I challenged the competency of their ability to handle the cases. That's not the point at all. In fact, I explained to some of my colleagues who are worried about the experience component that if one of those judges, unfortunately, were not judged tomorrow, there would be an election, and another person would be elected, and there's really no requirement that they have some kind of constitutional certification or some kind of special talent in order to hold that seat. So basically, any judge has gone to law school, has been vetted, has become a judge, has been elected by the voters, and our jurisdictions is competent to handle these types of matters and preside over them. The process thereafter would be exactly the same. So after the panel reached its decision, then it could go to the Court of Appeals or subsequently to the Kentucky Supreme Court. So this creates a new system. It would allow the plaintiff to file where they reside. The lawyers typically that are involved would not be the ones necessarily traveling, if we traveled at all, because this also provides, under this new pandemic situation, we've learned that we can do a lot of things virtually by Zoom, WebEx, etc. And this would allow them to conduct matters in a virtual way, but those would be publicly accessible, and that's pretty much mandated under this particular language of the bill. That is the essence of what we are trying to accomplish. Largely, it is a fairness issue that you should, in all other cases, in civil cases, even in criminal cases, they're charged in criminal cases in the jurisdiction where the crime was committed. In civil cases, you bring the action typically in the jurisdiction where the incident occurred. But in these cases, even though the incident that triggered the claim may arise in Boone County, for instance, you would have to originate, in most cases, in Franklin County. Now, there's a question that came up yesterday about the case recently decided that was heard first in Judge Brueggemann's courtroom in Boone County. That was an as-applied situation. So there are circumstances where it can still be filed in that jurisdiction in certain instances. But by and large, any kind of major claims of that nature would be brought in the place of original jurisdiction, and then it would be assigned to this three-judge panel. We've put in there provisions that until the panel becomes impaneled, that the circuit judge where the case is filed could enter an order, and there would be a chief judge that would be assigned of that three-judge panel. But once that panel was formed and took jurisdiction over the case, they would maintain that jurisdiction over the case. The last thing is that if there is conflicting situations where there's multiple cases in multiple jurisdictions involving the same topics, then in those instances where that occurred, then the cases would be consolidated, and they would be heard by that original panel in the original jurisdiction where the case was held. We have worked on this for quite a while. In fact, I know from talking to many of the senators and from the House members that this has been worked on even before my time, before I came to be in the House. And so the language, a lot of the language that's in there has been worked through on the Senate side and on the House side. So that is the bill that's been presented here today. That's the bill that was passed in the House yesterday, and we would certainly appreciate your consideration of that, and certainly I'll answer any questions.
Senator Schroeder.
Thank you, Mr. Chair. Thank you, Representative Massey, for bringing this bill. You're correct. I know just from talking to members, this is an issue that has been around a while. I had a bill a few sessions ago dealing with this and came to learn that I believe President Williams, then President Stivers, then Leader Thayer all carried it. So this has been an issue I know that's been around for a while. I agree your opening statements about I believe, in Kentucky we elect our judges. I think it's only fair that when you have an issue in the county that you live in, that you should be able to bring that before an elected judge. And we are 100% on the same page there. And that is not any reflection or negative feelings towards Franklin Circuit, because frankly, I haven't practiced in front of the judges in Franklin Circuit. I know there's different views, but I just think it comes down to you should be able to be in front of the judges that you elect. So I think we are on the same page. We both want to get there. I think at this point, maybe, I'm saying let's take 75 back home, and you're saying let's take 127 back home. So I'm trying to understand the three panel versus just having a single judge do it. And you had mentioned the Boone County case. So using that, because that's, a real example we could reflect on, a recent example, why in that case he would have two other judges from nearby counties selected by Chief Justice, and then they would be impaneled?
Actually, in that instance, Judge Brueggemann wouldn't have been the judge, because the way the panel works, it's a random selection of a judge from each of the three areas created by boundary and geography. The reason for the three-judge panel has more to do with critical issues that we believe it's better for three sets of eyes and three minds to look at than one, and also for expediency, because depending on when the cases are heard, you could have multiple cases across the Commonwealth running at one particular time among various panels, as long as they were separate topical issues. So that was the rationale behind that. It had been discussed about just making it that these claims, instead of going to Franklin County, would go to the court of original jurisdiction and be heard by the judge in that jurisdiction. So that has not been left out. That has been discussed. And the people that have worked on this felt that the better option was to have three heads are better than one to look at this. It's more balanced. It involves our circuit judges, who I believe take interest in these issues that affect us, that affect all of us, and that it obviously spreads it out over the Commonwealth, as opposed to directing it all onto the shoulders of two judges in Franklin County. And I've tried to be very careful about that. Again, I have practiced in Franklin County, and I wouldn't say, and I'm not saying anything negative about those judges. They've had a good caseload and they've done a good job. What I'm saying is that just an abundance of fairness to all Kentuckians, to the voters who have elected these judges, that they should be able to have their cases heard in a broader manner, in a fair manner around the state of Kentucky.
Sorry, I appreciate that. Thank you. I'm still a little murky here on if we could use Boone County. If you could just walk me through that. The case is filed in Boone County. In this instance, it was with Judge Brueggemann, but according to you, that he might not be the judge, or he couldn't be.
He could be.
Okay.
If it was as applied, but in most cases, what would happen is it would be filed, and then the case would be certified to the Chief Justice. A judge would be randomly selected, so it wouldn't be that the Chief Judge had the ability to pick which judge he wanted to hear the case. Be randomly selected, one from each area, and then that would be the panel that would hear the case. They could hear that virtually, they could hear it in the jurisdiction, but the case would originate out of the jurisdiction where the plaintiff resided. So if that were the case, it would be held in that jurisdiction if it was an in-person hearing. But if it was a virtual hearing, of course, there would be arrangements made with our Zoom abilities, et cetera, to accommodate that.
So when you say in the area, so using Boone County again, would you be looking at, only we're going to select within did you use the Supreme Court of Appeals jurisdictions? Is that the area? Is it neighboring counties?
So if you look at page 3 of the bill, section 3, there's the counties comprising the districts from which circuit judges shall be selected for hearing challenges under this section will be as follows. And there's 3 districts or areas that are defined there. So there's in the 1st district and 2nd district and 3rd district. So it'd be one judge from each of those 3 districts, so that realistically you're getting the 3 panel members are a broad array from across the state. You could have a judge from Kenton, a judge from Fayette, and a judge from Pike County that would hear the case. And again, we think also, in a matter of abundance of fairness, is that we all know our communities are different, our cultures are different somewhat, and we may have different philosophies or views. So this allows these three members to hear the case, discuss among themselves, and to reach a decision. So that's why we believe it's a much more fair process dealing with these critical issues that affect all of our Kentucky constituents.
Thank you.
There are two other members that have questions, but before we get to them, I'm going to go ahead and call the Chief Justice if he'd come up. Chairman, if you'll hang around.
I will be here.
Thank you. Chief, we're glad to have you. When the table's vacated there, you can come on up. Appreciate your patience. Chief Justice Minton, always a pleasure to have you before the Judiciary Committee, and you're always welcome here.
Thank you, Mr. Chairman, and I appreciate sincerely, members of the committee, the courtesy extended to me. I wasn't given an opportunity to speak before the House, and so the House has not heard from the judicial branch on this matter. So I'm really pleased that the Senate has invited us to at least be a part of the conversation. Thank you. Mr. Chairman and members of the committee, you know, years ago there was a who became very famous cartoonist who's came to be known as Rube Goldberg. Rube Goldberg became famous because he drew cartoons of these elaborate and contorted processes aimed at solving a simple problem. So what we have here, and I hope from this point forward, if I accomplish nothing else, Mr. Chairman, we're fond of naming bills for people. We have Mandy's Law, we have this and that. This needs to be Rube Goldberg's effort at judicial reform. It creates such a convoluted, complicated, imponderable process that, you know, I don't take lightly the obligation to come before a legislative committee and address it on a matter of legislation. I just don't do that. But there's nobody else in the Commonwealth who constitutionally is compelled to manage the court system. I am that person by virtue of my election by the people of my district and my colleagues on the court. And so I got up at 4 o'clock in the morning, rolled out of bed this morning in Bowling Green and came here because this is so important that I couldn't stay at home and monitor virtually the adoption of this Rube Goldberg bill. And for a couple of reasons, important reasons. You know, the last few days we've heard repeatedly coming from D.C., from Washington, D.C., the important message from our congressmen and senators is let's tell the people the truth. Let's tell the people the truth. So I'm here today to tell the people of Kentucky the truth about this bill. House Bill 3, without mentioning any names, is just very simply an effort to eliminate the Franklin Circuit Court from the decision-making process in these cases. Let's just tell the people the truth. That's what it is, nothing more or less. But yet we're going to construct a system, if this bill is adopted, that will totally upend the work of circuit courts all across the Commonwealth. We are to solve a problem of eliminating 2 judges. We're going to upend the work of judges in 120 counties across the Commonwealth, and here's why. The bill is, secondly, let's tell the people the truth. It's built on a fallacious assumption that circuit judges sitting anywhere, from Fulton to Pikeville to Covington to Louisville, wherever, they are fully capable, under the current law, of hearing and deciding constitutional issues. There is just absolutely, and it amazes me that a number of lawyers that signed on as sponsors to this bill would advocate a proposition that is legally so unsound. circuit judges everywhere have the ability to rule on constitutional issues. And as Senator Schroeder zeroed in, if you were to consider, let's just say, the case that was filed in Boone County this past summer before Judge Brueggemann by by the track, by the people, the child care company, the child care group, those are citizens of Boone. They would be deprived under this bill of allowing Judge Brueggemann to hear the case, because what it would do, first of all, it would require the circuit clerk of Boone County, without consultation with anybody, because this bill says automatically within an X number of time, the circuit clerk is to certify the matter to the Chief Justice, who then must select a judge, a panel of 3 judges from 3 counties, 3 super circuits that have been created by the General Assembly to hear the case. And so, there's a possibility that the judge, Senator Carroll, would come from Fulton and from maybe Bowling Green or Pikeville. Anyway, the 3 places. I will say that the way these are drawn, there's a high likelihood there's going to be a judge from Lexington or Louisville based on the way these districts are created, because there are more judges, and the bill doesn't differentiate between general jurisdiction and family court judges. They're all circuit judges. They'd all be in the pool. They'd all be under consideration. So there's very high likelihood that any case arising any place in the Commonwealth will be heard. At least one of those 3 judges will be from one of those 2 places. So the Golden Triangle is well set to the detriment of the rural counties in this bill. It just accomplishes that. This Rube Goldberg bill accomplishes that. The reason I really wanted to crawl out of bed and come here today is to tell you that this is an egregious invasion of the separation of powers. How many times in this bill, Mr. Chairman, does it direct that the Chief Justice shall? The Chief Justice shall. Our constitutional system gives deference, just as the Chief Justice would not even presume to dictate how the General Assembly would decide matters of budget. I would never presume to send an order over here, Mr. Chairman, indicating that the President of the Senate should divide the Senate into X number of committees to decide how to budget. Well, this is what this does. This directs the Chief Justice, and the Constitution is clear that how the business of the Court of Justice is handled is constitutionally given to the Chief Justice of the Commonwealth. So here's my point, very simply. This Rube Goldberg bill is an unconstitutional invasion. It is overkill. If the General Assembly wants to deal with the matter, it says it's a venue bill. Let's tell the people the truth. It's not. It's not a venue bill. It's about eliminating the Franklin Circuit Court. So if, as has been discussed, and I realize that this issue's been around a long time. As long as there's been a Franklin Circuit Court, it's been around. Senator Schroeder drafted a bill. It was a 200-page bill during my tenure that very surgically attempted to deal with the matter of special jurisdiction and venue. That approach is not inappropriate. This one is. So if we tell the people of the Commonwealth the truth, this bill needs to die. It is there. I'm not saying that there's not an appropriate constitutional way to approach it, but you're hearing from me that this is not it, in my opinion. And I'm happy to answer questions.
Thank you, Chief, and we do have some questions, but I want to respond, and I mean this. I hope you know I mean this with all the respect in the world for you as a person, as a friend, and as a colleague, and certainly out of immense respect and appreciation for years of service on the bench.
I'm buckling my seatbelt. With that kind of wind up, there's bound to be a pitch here.
The court gives us orders all the time. Just 2 months ago, every voter in the Commonwealth that showed up at the ballot box had to see the entirety of 2 constitutional amendments, because the Supreme Court ordered the policy-making body of the Commonwealth to do that through a ruling 2 years earlier. And I'm not going to argue about the merits of Marcy's Law or the other amendment regarding judicial terms of office and years of experience. But the court does give us orders all the time with which we comply. I still disagree with the court's finding in that particular case requiring the entirety of the amendment. And I was there for the oral argument, and I heard the members asking about how many words were in the ballot question in 2018, and that was a big point of contention with members, and evidently in the conference with you all, I'm sure it was discussed. I'll say, for comparison's sake, the judicial article in 75, I had it prepared on 8.5 by 11 like a bill request would be modern. It's a 10-page amendment. Imagine if the voters had to read and comprehend all of that. So, again, with all the respect in the world, and I have it for you, Chief, I do, but I disagree. You tell us what to do all the time. And secondly, I don't dispute this is an opportunity to get things out of Franklin Circuit Court. It's not to get rid of Franklin Circuit Court, as you've said. It's to get these special kinds of hearings out of Franklin Circuit Court, because that makes that a super jurisdiction. And frankly, I'm not worried about the 2 judges that sit there, and I've got a ton of respect for both of them. I've not practiced in front of Franklin Circuit Court. I've been in front of them in litigation because of Marcy's Law, but I haven't practiced in front of them. I don't know either of the men very well. I'm not worried about the 2 of them as much as I am when they retire. And then the campaign for Franklin Circuit Court becomes something that any other circuit judge race is not like around the Commonwealth. And it's because that jurisdiction has this special power here, this special jurisdictional authority. That's what those 2 judges, as you have rightly said, don't have any more qualifications than any other sitting circuit judge in the Commonwealth. Yet they carry an immense amount of weight, those 2 seats do, and I think that's not appropriate. So is this the version, and I support House Bill 3, but is this the version? I filed this, as you might remember, about 5 or 6 years ago. It was a 400-page bill because we made changes to all the conforming amendments, and it wasn't a 3-judge panel. This isn't the way that I would build it if I was filing it again, but I do support moving things out of Franklin Circuit Court so, frankly, those 2 men can get around, or women one day, get around to hearing just the cases for the people in Franklin Circuit. And these other cases of statewide import can be heard by lots of different judges. So I say all that, and I know you want to respond, but I know President Stivers has a question, and I want to let him ask, if I could.
Okay.
Thank you, Mr. Chairman. Chief Justice, truly, I'm going to say this and then talk to you as the chief executive of the judicial system, but caveat it that I think Senator Schroeder said there was a couple of different ways to get to Boone County from here. We could go up 64 up 75, or you could take 127 and pick up 71. So I think what you see is that there is conformity to the point that Representative Massey wants to get to, and the point that we want to get to. We may think there's 2 different directions. And I'm not sure, and this is kind of a question, you think there is a point that we can all get to, too, that does what we are thinking. Am I correct?
You're correct.
Okay. Now, understand the frustration of the General Assembly. And it goes back to a discussion, and you and I have, and I've asked you to sit on committees with me at a national level. The frustration being that we are the group that appropriates. And I'm not so sure that John Schickel thinks that Judge Brueggemann shouldn't have heard that case. I think that was his name, am I right? But when and so there theoretically we may have differences about how we get to Boone County, but the frustration comes back to every 10 years, the court tells us to redistrict, and if we do it right or wrong, but the courts never redistrict themselves. Jefferson County, and if you think about this, and again, this is the frustration, and I truly have the utmost respect, and we've had some wonderful conversations. How do you think about African Americans and other people in Jefferson County when they elect and their vote is devalued, diminished, because they only have the opportunity to elect one Supreme Court justice when they're almost 20% of the population? Constitutionally, under state or federal, if this is an electoral system, people aren't being appropriately represented on the courts. And some smart attorney is going to file an action in federal court to do what you all tell us we have to do every 10 years, but you've not done since my father was a circuit judge in 1963. Secondly, and I'm saying this so the public, because we've had these conversations. When you think about Franklin Circuit Court and the opinions, and I do read the opinions, and I sometimes wonder, because judges are only to look at the cases before them and say whether they have constitutionally applied laws, equally applied laws, various theories, and if they are or are not, but they are not then to inject their opinions as to what should be done. And that has been done on more than one occasion by one of the judges. Most recently, and I agree with the underlying opinion, that the MCO bid process was wrong. That's all he should have done. But then he went ahead and rewrote the contracts. That's either an executive branch function or a legislative branch function. Really, it's an executive branch function in conformity with the guidelines the legislature puts on them. And then I totally agree with the decision that came out on the process of the historic horse racing issue. A judge doesn't allow discovery, a basic premise of litigation, and you have to go up to the Supreme Court 2 and 3 times to get a judge to adhere to a basic premise of that. And then, and again, I'm agreeing with you all in your ruling, but the frustration becomes what happens to judges that blatantly do things that we know are outside of the realm of their constitutional mandate? Nothing. What happens when we know that judicial districts, judicial circuits, and appellate districts are outside what I believe constitutional requirements of equal representation? 1963 to 2020 is 57 years. I know we've been working on that, and we've had to push, and Senator Schickel and I have pushed on that, sometimes to the detriment to my own region. But we are now, and I agree with you that I'm not sure I agree with Senator or Representative Massey in how he wants to get to Boone County, but I agree we need to get to Boone County. So we're speaking the truth. And that's the truth of the situation. I'm not disagreeing with you that this is a Rube Goldberg type of situation, but we need to know that what we're hearing and what we want to see from the courts that is equally applicable to us is applicable to you all. And the same rules and processes, because we get complaints and things of that nature, are going to take place within the court system. That you as the lead of the court is going to be the lead of the court and come to us with ideas and suggestions because you think this is the way it should be appropriately done. So I asked the question, yes, you think it can be done, so how can it be done?
Well, I know that in conversations in the past, well, I don't know kind of how to begin here. There's been a lot laid out here for me to respond to. But
No, really, there's only
let
one
me-
thing to be
is
responsible.
how do we
let me
get
time
how
out.
do we get to Boone County on
How do we get to
127?
Boone County?
Let me pause right here. And before you answer that
You're gonna call
question,
time on me?
I don't feel like I have the power to do that. So, but
Well, you do.
for housekeeping purposes, I'm just going to say, and the witnesses have been told, we're not going to hear House Bill 2. So, folks, Jackie, I'm going to have a called meeting at some point. And Kate, I know you've both been there. We'll make sure you get a link to do this again. We may have to come back over here if we're going to do Zoom. I don't know if 327 is set up. We'll make sure that you're still participating when we have the meeting this afternoon, and I don't know when that'll be, but we'll make sure you both know. So, and Tom, I want you to have a chance to speak, but I'm going to let the chief finish, and we do have a hard deadline here right at 11. But members, Tom was going to speak, but his testimony was sent to you all by email and is in your folders right now. So I want to make sure you are aware of Tom Fitzgerald's thoughts on House Bill 3. He also opposes it and has constitutional concerns, and he has set those forth in his testimony. And I wanted to make sure members saw that. So with that, Chief, you have the floor, and I'm going to let you and President Stivers duke it out for the last 10 minutes here.
Well, he and I are not going to duke it out too much because he and I agree on quite a few of the points he made. And one is, the court on this list. Let me just bring up the redistricting issue that Senator Schickel and I have talked about. We have sent over. I acknowledge the length of time involving drawing appellate districts. That is a legislative function, totally a legislative function. We've sent plans over here twice that I know of.
And I've supported them.
Well, I mean, I'm just saying that this is not a matter that's been left for 57 years to molder. It's been discussed, and December the 31st, we were required to submit our weighted caseload study, and we performed that, and we submitted it, and it's done. Now, it's not perfect, but it's a start, and it needs to be addressed, and I guess that's another matter we need to get to. So I want you to know that I'm not turning a blind eye to any of this.
Yes, sir.
We're trying to do that. Now, the point about, obviously we all understand the frustration that legislators and governors feel when courts take a different view on constitutional issues. It's just the uncomfortable nature of the system that we live in, and it's built for that discomfort. But it's also built for a system that, we have to stay in our own lane, and this is why I'm here today, is because this one gets off the track. Now, yes, the General Assembly defines venue, and this bill is inappropriately called a venue bill, but it doesn't really address venue at all. If Senator Schroeder drafted a bill, I don't remember the details of it, but it attempted very, very precisely to address all of the places where, over the history of the Commonwealth, the wisdom has been that there be a circuit court in the state that deals with matters relating to state government. That's not unusual. That's the way it's built in most states, if not every other state. And that's the way it's built in the federal system with the federal circuit in D.C. They are the ones who develop sort of a level of expertise dealing with administrative agencies and matters of state government. They just do. But that's not carved in stone. That's carved in statute. And so if you want to, if the policymakers believe that there's a more appropriate way to do that, then that's a way to approach it, perhaps, with this special jurisdiction, dealing with each piece of legislation like that. So there is a path to Boone County. But what this bill does is it ends the path to Boone County, because a Boone County case will end up being heard by a 3-judge panel from who knows where in these super circuits, not created by Constitution, but created by this piece of legislation. And I guess just to address directly some of you who are trial lawyers, can you imagine? And Senator Schickel, let's use a baseball analogy that'll help us all. I got a colleague that believes everything resolves to baseball. Suppose the game is played with 3 umps behind the plate, and the pitch is thrown, and you've got 3 umps behind the plate, and one says, that's a ball. And the other one said, no, I think that was a strike. And so we got to turn to the third. So, you talk about an inefficient way of trying cases, because we're not dealing with appellate judges here. We're dealing with the trial bench where cases get tried and objections get made and rulings have to be made right then. There's not time for a committee meeting, between every pitch. It's just not. This is the Rube Goldberg way to do. And it's just, it is a disservice to the taxpayers of the Commonwealth for us to go down this path.
Chief, I appreciate it. I thank you, and I appreciate your coming. And I don't know if, Laura, you came up here if you wanted to say anything.
She stayed masked because she... Go ahead.
No, sir, I just wanted, there were a lot of questions.
Sure.
To him, and I just wanted to make sure that he was able to get them all. So I was just kind of writing them down.
Got it. I just wanted to give you the chance. We're not going to vote the bill today, or at least not at this meeting. Obviously, we don't have the time. And I know Senator Schickel had a question, Senator Wheeler had a question, and I want them to have a chance to speak, at least with the sponsor, because they both raised their hand or got my attention while the chairman was speaking. So I'm going to let them do that in between now and when we have our next meeting, which might be, members, at 1 o'clock. Possibly right back in this room, which I think is vacant for the rest of the day, So my hope is that we can be back here at 1 o'clock, and we'll get, Tom, did you hear that?
Sure did, Mr.
Okay.
Chairman. Thank you.
We'll make sure you get a fresh link if one's necessary. So with that, I'm going to call for a motion to adjourn for now. We are adjourned. Chief, thank you.
Thank you.
Laurie, thank you.
I'll be back at 1.
Yes, sir.
Okay. I'll be here.